Following amendment, the clerk will please read the amendment.
Amendment by Sarah Davis of Harris.
Chair recognizes Representative Davis of Harris to explain her amendment.
Thank you, Mr. Speaker and members. I am offering an amendment very mindful and respectful of the deeply held religious and political beliefs that I know every member of this House has. This amendment is a relatively simple amendment. The amendment bans abortions at 20 weeks or later, with 4 exceptions: health of the mother, severe fetal abnormality, rape, or incest. And given the debate that we just heard, I had anticipated that. And in terms of rape or incest, it requires medical judgment that presents a possibility of serious self-harm or suicide. And then it strikes the rest of the bill. You have an opportunity to vote on a bill that I believe will actually be held constitutional. I believe that the bill as it is drafted is going to result in a de facto ban on all abortions.
Mr.
Not at
King.
this time.
Will the lady yield for
No,
questions?
not at this time.
She does not yield at this time, Mr. King.
Does she intend to yield for questions?
Yes, I absolutely will.
She intends to yield.
No matter where you fall, what side of the argument on this issue you are on, the truth is there is a constitutionally protected right, and we are not debating this issue. We are arguing with each other. I don't believe that anybody on this floor is pro-abortion. This is not a Republican issue versus a Democrat issue. There were Republicans that opposed this bill. Well, one. There were Democrats that supported this bill. No one wants to see abortion. It is a horrible way to end a pregnancy. But it is a constitutionally protected right. And the case law indicates that there is a growing state interest in protecting that life the further a woman gets in her pregnancy. And I believe that if a woman is carrying a child to 5 months, I agree with Representative Lavenberg, and I agree with many of you, but that woman had a choice earlier that she could have made. And 5 months is probably too long, with some exceptions. So I will ask, I know that this motion will be argued to be tabled. I will ask you to vote against the motion to table. And we've already heard this in the debate last session and probably for the rest of the day. But this bill as drafted is opposed by essentially...
Mr. King.
Will the lady yield now for questions?
Lady yield.
And not at this time.
Not at this time, Mr. King.
This bill as it is drafted is opposed by pretty much the entire organized medical community. And I believe it's because of the parts of the bill dealing with privileges for physicians and the ambulatory surgical center standards. So I ask that you actually vote to make a difference, because I know that's why we're all here. I would ask that you put policy over politics. This debate is not about anyone's primary. This is about passing legislation that protects women and the rights of the unborn in a responsible and constitutional way. So with that, I will yield to my colleague.
Mr. King, the lady yields for questions.
Thank you, Representative. I wanted to make sure there was a little confusion on the last amendment. Your amendment is virtually identical in substance to that of Representative Thompson's. And the statement had been made previously that we had voted last session for a rape and incest exception. Would you agree with me that that exception that we voted for on the sonogram bill was not an exception to abortion, but would you agree with me that that was simply an exception to not have to take the scan?
First, I will say that my amendment is not identical to Chairman Thompson's amendment.
But it is a rape and incest exception.
It includes health of the mother, severe fetal abnormality, and rape or incest. Those are the four
and fetal abnormalities already in the current bill, isn't that
yes,
correct?
Sir. As defined in the current bill, there's no part of my amendment that redefines it. It's as defined in the current bill.
So essentially, your amendment, the only change that it really makes is with regard to rape and incest. Is that correct?
And health of the mother, yes.
Okay.
And it strikes the rest of the language of the bill. So it strikes the.
Would you agree with me that there's no current exception for rape or incest, no exception to an abortion for rape or incest in Texas law, and that the amendment we voted for on the sonogram bill was simply an exception for rape and incest to submitting to the scan? Would you agree with me on that?
I believe that federal law actually prohibits third trimester or late term or partial birth abortions regardless.
That is correct, regardless.
And as far as the amendment, you're asking me if the amendment on the sonogram bill to allow women who have been victims of rape or incest.
I just wanted to clarify that the rape and incest exception, that we do not have a current rape and incest exception in Texas law, and we did not vote for one last time on the sonogram bill, that all that was an exception to the scan.
Well, I believe that the exception in the sonogram bill was in fact to exempt a woman who is a victim of rape and incest from having the sonogram.
That's correct.
Yes,
from taking the scan. Now, one other question. You mentioned when you were laying out your amendment, you mentioned that virtually the entire medical community opposed HB2, but
I believe that the organized medical community, including Texas Medical Association, the Texas Hospital Association,
the Texas Medical Association was neutral on this bill, were they not?
No, I don't. They wrote a letter in opposition, and I'm happy to print that off.
I believe they registered in neutral on the bill. And I'm also correct that.
That's not to say that is the opinion of every doctor, because I've watched the testimony, and there are plenty of physicians, including physicians on this floor.
5 of the 6 physicians in this body voted for this bill in the previous session.
Absolutely.
And I just wanted. You mentioned also, you said that 5 months may be too late.
I believe that it is.
I believe your exact words were 5 months may be too late for the child, to abort for the child. Would you agree with me that at 5 months, I know a lot of people have a lot of disagreement at when is viability and what is a baby, what is it in the womb at 3 months, 2 months, there's disagreements with that, but would you agree with me that at 5 months, by any medical or ethical definition, that this is a baby in the womb?
I am not a physician. I cannot give any medical
advice. I'm just asking if you would agree with me.
I can tell you personally,
would you agree this is your amendment to allow these abortions?
When I think
I'm wondering,
if I think of a woman carrying a child to 5 months,
that is a baby in the womb.
I see a baby when I look on that sonogram. I do, and I have seen. In my role of serving in public health, I have visited hospitals all over the state, and I have seen.
You agree that is a baby within the womb?
Babies born at 22 weeks, and they have fingers and toes. I am deeply sensitive to this issue, regardless of what you may think.
Well, I know you are, Ms. Davis, and I'm not disagreeing with that.
Some exceptions.
Would you also agree with me in this? Since you've agreed that is a baby in the womb at 5 months, would you also agree that baby does not know whether it was a product of rape or incest or a loving family? Would you agree with that?
I would assume not.
Thank you. Thank you.
Mr. Speaker.
Mr. Wu.
Will the gentleman yield for questions?
Lady yields for questions.
I yield.
Lady yields, Mr. Wu.
President Davis, you said earlier that the right to have an abortion is a constitutional right. Is that correct?
I believe that, and I'm not a constitutional scholar, but I do believe that it is a protected right through case law handed down to the United States Supreme Court.
And I want to be clear, I'm not a constitutional scholar either. I think maybe we're just both two simple country lawyers. But here's the thing.
I'm not a former prosecutor, so.
Do you know that the right to have an abortion was established by the U.S. Supreme Court exactly 40 years ago in Roe versus Wade?
I am aware of that.
And the U.S. Supreme Court, in their decision, equated the right to be able to control and make a decision.
Representative Stickland raises a point of order. The lady's time has expired. The point of order is well taken and sustained.
Mr. Speaker.
Mr. Wu.
Mr. Speaker, I move to extend the lady's time.
Members, this is the first extension of time. Time is extended. Members, first, if you don't mind, I'd like to excuse Representative Riddle because of a family funeral on a motion by Representative Linda Harper Brown. Is there any objection? Chair hears none. So ordered. Chair recognizes Representative Davis on her extension of time.
Representative Davis, do you know that the U.S. Supreme Court stated that even though it is not specifically spelled out in the Constitution that the right to control someone's reproduction is a constitutional right? Do you understand that?
Yes, I believe it falls under the construct by the court of the right to privacy.
Absolutely. And this right to privacy, the court notes, actually comes from both the First Amendment, the Fourth Amendment, the Fifth Amendment, the Ninth Amendment, and the 14th Amendment. Does that sound about right?
Yes, sir.
And because this is a fundamental right, it requires a compelling interest to overcome this high hurdle. Does that sound about right?
Yes.
And this, not only does it have to be compelling, laws that are passed have to be what we call narrowly tailored. Is that correct?
Yes.
Do you know that other courts around the United States have already ruled on the parts of the bill that you are looking to strike out?
I believe that there have been rulings that have held these parts to be unconstitutional.
And not just a few rulings. You know that Wisconsin, not more than one day ago, struck down the law, put a temporary injunction on the law stating that it is likely to be found unconstitutional. Judge Connolly, in his decision, wrote, there is a troubling lack of justification for the hospital admitting privileges required under the law, adding, moreover, the record to date strongly supports a finding that no medical purpose is served by this requirement.
Yes, sir, and I think that's especially true in the state of Texas because current law already requires that any physician that's performing abortion services has to either have privileges in a local hospital or have what's called a transferring agreement with a physician that has privileges in that hospital.
Absolutely, and you know that the state of Alabama has also enjoined this exact same law. You know that the state of Mississippi has enjoined and stopped this exact same law. Right?
That's what I've read.
And in fact, your amendment also strikes out a part of the bill that talks about RU 486, or the application of medical abortion. Is that correct?
Yes, it strikes all of the bill except for the 20-week ban because I have consistently since my last term, which was my first term, voted against interference in the physician-patient relationship. And as conservative colleagues of mine on the floor have consistently said that they believe in that. I don't think the legislature should be practicing medicine.
Absolutely.
We do have some physicians here.
You know the Oklahoma Supreme Court agrees with you too. The Oklahoma Supreme Court, in striking down the provision that controls the taking of medical abortion, of chemical abortion, dealing with RU 486 and related type of drugs, actually says that the challenge measure, which is almost word for word exactly the same as this bill, this challenge measure is facially unconstitutional, end quote.
Yes, sir. And that's really the point of my amendment, because I believe that this body is getting ready to pass legislation that is unconstitutional. But I, like everybody on this floor, I believe, care about the rights of women and the rights of the unborn, and we want to do what we can to protect them within the confines of the Constitution.
Absolutely. And you know, the North Dakota Supreme Court also agrees with you in that, striking that same exact provision in their state, they stated that the legislative mandate that physicians follow this badly flawed and outmoded FDA protocol would force them to expose their patients to unnecessary risks, to abandon current standards of care, and to compromise fundamental canons of ethics. They added, the judges found the lack of exceptions troubling, calling the absence of a health exception unacceptable, and the lack of an exception for victims of rape and incest unconscionable.
Yes. And earlier it was indicated that the Texas Medical Association registered as neutral, and we've just double-checked, and that's not true. So this language is opposed by the Texas Hospital Association and ACOG and the Texas Medical Association. Although I agree that not every practitioner is opposed.
Absolutely. Were you watching, did you observe any of the House committee hearings?
I did.
Okay. And do you remember the Texas Hospital Association came and testified?
I did, and if I remember correctly, to paraphrase the testimony, is essentially the physicians would not be given these privileges for reasons such as the hospitals cannot, they're not overseeing what these doctors are doing. So I think that's kind of the real problem with the bill, is the privileging aspect. And Representative Chairman Turner spoke extensively about it in the House hearing, because if a physician cannot get a privilege, get the privileges, which the hospital association says they will not, then there will be no abortion services in the state, regardless of whether or not you have 5 ambulatory surgical centers that can perform abortions or 500.
Representative Davis, can I ask you, you represent the medical center in the city of Houston, don't you?
I represent the world-renowned Texas Medical Center in Houston, Texas.
And in your time there representing that district, you've had a lot of time talking to medical experts, doctors, physicians, etc.
Yes.
And you understand basically how admitting privileges work.
Yes, I do. I'm not an expert on it, but okay. I do.
So basically, it is solely up to the discretion of the hospital.
Yes.
They can deny admitting privileges for any reason, even if it's unconstitutional.
That's correct.
Okay. Even if the admitting privileges would cause a de facto ban on abortion in Texas. And even if that happens, it's up to them.
That's right. And I think that sets up the undue burden
Members,
that the Supreme Court has said in Planned Parenthood that it's unconstitutional.
Members, we need to confine our debate to the amendment before us. We would request that your questions be on the amendment that is before the body. Thank you.
Mr. Speaker.
Mr. Wu.
Parliamentary inquiry.
Please state your inquiry.
Is a discussion on admitting privileges germane to an amendment that removes admitting privileges requirement from the bill? Or from the amendment?
The bill is still before the body, or just the amendment. Has the bill been withdrawn?
As a general question, yes, but it depends on exactly what the amendment covers, Mr. Wu. If you want to come down and have a discussion, I'd be proud to do it.
Absolutely, sir. Thank you, Mr. Speaker. Mr. Speaker.
Please, Mr. Wu.
Parliamentary inquiry.
Please state your inquiry.
Is it my understanding that if the bill is still on the floor, we can still have discussions about the bill itself, even if we're on an amendment?
No, Mr. Wu, the discussion has to be on the amendment before the body.
And, Mr. Speaker, on the inquiry,
Certainly, Mr. Wu.
would you be able to point me to which part of the rule states that?
Give us a moment. We'd be glad to.